Hello and welcome to Delhi Law Firm. Today we are discussing a very important Supreme Court decision that directly affects children, parents, schools, and the future of our society. This conversation is meant to create awareness so that ordinary people understand their legal rights.
This Supreme Court decision deals with the Right to Education Act, 2009, especially the obligation of schools to admit children from weaker and disadvantaged sections.
The key issue before the court was simple but serious. Can a neighborhood private school deny admission to a poor child even when seats are available, just because technical procedures were not followed?
The Supreme Court made it very clear the right to education cannot be defeated by technicalities.
In this case, a father tried to admit his children in a nearby school under the 25% quota meant for economically weaker and disadvantaged groups.
Through RTI information, it was revealed that hundreds of seats were vacant. Still, the children were not admitted.
The High Court had earlier stated that the parent did not take appropriate steps, mainly because the online procedure was not completed.
But the Supreme Court asked an important question. Can digital illiteracy, language barriers, and lack of assistance be ignored in a country like India?
The court held that education is not a charity, it is a fundamental constitutional right under Article 21A.
This right applies to every child between 6 and 14 years, without discrimination based on wealth, caste, or social status.
The Supreme Court explained that when a right exists, duties automatically follow.
According to the court, there are 5 duty holders: the government, local authorities, schools, parents, and teachers.
The government must ensure availability of neighborhood schools.
Local authorities must track children, monitor admissions, and prevent dropouts.
Schools, especially private unaided schools, have a legal obligation.
They must admit at least 25% children from weaker and disadvantaged sections in Class 1 and provide free education till completion of elementary level.
This obligation is mandatory, not optional.
The court clearly stated that these children cannot be treated differently, segregated, or isolated.
The Supreme Court beautifully explained the constitutional vision behind this rule.
It said that a child of a wealthy family and a child of a daily wage worker should be able to sit in the same classroom and learn together.
This is how the Constitution promotes equality and fraternity.
Education is not only about textbooks, it is about social integration.
However, the court also acknowledged a serious problem: poor implementation of the law.
Online admission portals are inaccessible to many parents.
Information is often not available in local languages.
Help desks are missing.
Seat availability is not transparently disclosed.
And applications are rejected for minor mistakes without giving a chance to correct them.
The Supreme Court strongly criticized this approach.
It held that applications must not be rejected outright without giving parents an opportunity to rectify errors.
The court also highlighted the role of the national and state commissions for protection of child rights.
These bodies are responsible for monitoring, grievance redressal, and enforcement of the child's right to education.
Importantly, the Supreme Court directed governments to frame binding and enforceable rules, not just guidelines.
Because without enforceable rules, the constitutional promise remains only on paper.
The court further stated that if 25% seats remain vacant year after year, authorities must investigate the reasons.
Schools can no longer say no one applied.
They must show that proper awareness, assistance, and transparency were provided.
Parents also have constitutional responsibility under Article 51K to ensure their children attend school.
But when the system itself becomes a barrier, parents cannot be blamed.
This Supreme Court decision gives strength to thousands of parents who are turned away from school gates every year.
It reminds schools that education is a social responsibility, not a business privilege.
It reminds governments that passing a law is not enough. Implementation is the real test.
The Supreme Court emphasized that true equality begins in the classroom.
When children grow up learning together, social walls slowly disappear.
This decision is not just legal, it is deeply social and constitutional in spirit.
It tells us that poverty cannot decide a child's future.
If your child is denied admission under the 25% quota,
If a school cites online procedure as an excuse,
if seats are vacant but admission is refused,
this Supreme Court decision stands with you.
law becomes meaningful only when people know their rights.
Awareness is the first step towards justice.
For legal guidance and assistance, visit dellylawfirm.news.
Because knowing the law empowers you and using it protects your child's future.